Hey guys, let's take a look at the Courtney Clenney case. She's the Onlyfans model who stabbed to death her boyfriend, and she's gone from trying to post viral Instagram pictures to trying to post bail. Let's see what's happening with that. She's in custody right now. She's still in custody. She's been in custody since she was arrested. She'd like to not be in custody. The state would like her to remain in custody. The victim's family wants her to remain in custody. And that's what the argument was about over these past few days in this hearing that she had that was streamed on the internet. So let's take a look at what she's charged with, what's going on in this hearing, and what can happen with it. So pretrial detention is about making sure the defendant shows up for trial and also safety of the public. And in Florida, if you're charged with a dangerous crime, you cannot be let out at your first appearance. It has to be a procedure later on, but you can be let out later on. And whether she's going to be let out and the terms and conditions of that are what's at stake in this hearing. So the arguments in this hearing were largely centered on, did she really commit this level of a crime? Was it self-defense? Because those things matter to whether she's a present danger to the public or not, and also whether she's likely to run and has the means to do that. So what's she charged with? She's charged with second-degree murder. And in Florida, that is this: the unlawful killing of a human being when perpetrated by any act imminently dangerous to another and evincing a depraved mind regardless of human life, but without any premeditated design to affect the death of a particular individual. So you didn't plan it, you didn't have premeditated murder there, but it happened, and the thing you were doing was super dangerous, and you should have known it probably would have killed somebody. You didn't care, you did it anyway, and then the person died. That's second-degree murder. Now, she says, okay, yeah, I did kill him. However, it wasn't that because it was self-defense, and that is justifiable in my case. So the statute in Florida for self-defense says a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm. And that's the case in pretty much everywhere. Is you got to be afraid to use self-defense effectively. You got to be afraid of that you're going to get killed or that you're going to be seriously injured, not just a minor injury. You got to be, and the threat has to be immediate. Now, sometimes, like here in North Carolina, the statute will presume that fear on your part. For example, if you're in your home or you're in your vehicle and somebody's breaking in, the statute will presume this level of fear for you, which justifies deadly force. That wasn't the case down here in Florida because they were both together in the place by consent. But she says, I was acting in self-defense. So she's trying to make the case that she was in a serious threat right away of either being killed or seriously injured. That's her self-defense argument. The idea is if you show the judge, look, yes, I killed this person, but the evidence really shows that it's highly likely that I did it in self-defense, and this was the only person who I had an argument with and never been violent with other people. The idea that you're a danger to the community drops than, say, if you're alleged to be a serial killer. That's just two different things. So that's the point of all of that. So let's get into what some of these factors that went on in the hearing that are a little bit unusual because some of it was very difficult to follow. It was kind of potato level technology in the courtroom, the camera having to be back there, and the judge, I don't think, had a mic. I couldn't understand all of it, and some of the streaming was cutting in and out, but it caught some of it. So you've seen in the news, if you've watched this case, a lot of recordings that the boyfriend made that definitely show Clenney in a terrible light. Terrible things she said about him, using racial slurs against him, threatening him, talking about hitting him, just horrible things, obviously out of control anger. He has these kind of recordings, and the prosecution wants to use that to show, look, she is violent. She's very violent. There's no self-defense here. She just killed the guy because she frequently would attack him, and this time she attacked him in a way that ended up killing him. That's what they want to show. Well, there's an issue in Florida. It's a consent state for recording other people. So here in North Carolina, if you have two people talking and one knows and the other doesn't, that's lawful. But in Florida, that would not necessarily be the case. If you have an expectation of privacy, then you have a right to not be recorded. And that's true for all the participants that are on this conversation. So this became an issue. Even though a detention hearing is not normally subject to the rules of evidence in Florida because of this consent law for intercepting communications, they have a separate statute that says you cannot use those intercepted communications in any proceeding, hearing, trial, or whatever. So the judge said, well, I'm not going to listen to things that are take into account things that are contrary to the statute. So let's have a conversation about that. And the parties argued it. The parties basically conceded that a conversation had occurred in the lobby of the condominium building, that would be okay to use it because you couldn't have an expectation of privacy there. It's a public spot. If you're talking there, someone could hear you, and the statute only protects those conversations that could be considered to be private by the person who's complaining about it. But back up in the actual home itself is a different story. And the judge ended up basically saying, if you're talking to somebody in your own home, that is a time when you would have an expectation of privacy. And if someone has their phone in their pocket recording you, that's contrary to the statute. The judge drew the line like this. If the conversation occurred in the home and it was in a normal tone of voice or such a tone of voice that it was unlikely to be heard outside the home, that would be considered within the scope of the statute and she would not pay any attention to it. However, if the person was screaming, as Clenney apparently often did, the judge would consider it because that could be heard outside the home. And if you're going to yell at the top of your lungs, you can't then later claim that you expected this conversation to be private because you were not keeping it private. People could hear it outside of your condominium. So that's how the judge did that. But interesting, because there are a lot of terrible recordings in this case, a lot of audio recordings that are just horrible. And it'll be very interesting to see how this affects the trial going forward, which can be used, which can't, because some of that is pretty good evidence of her mindset at the time this happened and before that. So now let's turn to the OnlyFans aspect. The state makes the argument that she's made a lot of money on OnlyFans and that she can make that money from anywhere. So she could be highly mobile. Therefore, she could run from this. She could take off and be anywhere and make a living doing what she does from any spot, any location. There's no monetary tie for her in any particular location, and that she's accumulated enough money that she could escape if she wanted to. That's their argument, is that therefore she's a flight risk. Now, the defense side says, hey, listen, she wasn't arrested for over 4 months. And if she were going to fly and take off, why didn't she do it then? Right? Well, the counter argument is she didn't know she'd be arrested. But still, it's a fair argument that she could have just moved and gotten the hell out of here. I don't know if they had her passport or not. If not, leave the country or go away or whatever. So she didn't do any of that I know of, at least. So I think she did, get out of the public in some way. But she didn't flee from the authorities in a way that she couldn't be found. No evidence of that, I don't think. So they're saying there's no evidence she's going to fly. She's got strong family ties. The family's willing to take her in and take care of her. They showed evidence that she maybe doesn't have as much money as people think that she does, what's frequently the case with people, and that the defense costs are going to drain her substantially for whatever else she does have. That's probably true. So, you can go either way on this one. Is she likely to take off and become a fugitive, or will she just stay with her parents or hang out or wherever she's told to and under whatever condition she has until the trial? I mean, couldn't they use GPS monitoring and take her passport and something like that? She hasn't shown I don't think, a prior indication that she would flee. Although the victim's family's attorney did come up and say that she'd had a warrant that she didn't take care of for years from another state, and that indicates a disrespect for showing up and taking care of legal things when you need to. So that's a good point too, I think. Who knows how the judge will weigh this, but she's looking at flight risk there, the likelihood, the capability to fly and the likelihood to fly, and do those things exist here? The other factor really, I think, is danger to the public. Is there a strong case against her that she's a danger to the public, that she potentially could reoffend again? Is she a danger to the public and other people? Is there a strong case against her? Well, in terms of a homicide, yeah. She killed the guy. She admits she killed the guy. There's no question that she killed the guy. Now, she says, I didn't stab him. I threw the knife and hit him. And she also says it was in self-defense. But there's no whodunit here. She done it. She killed him. Is she likely to kill other people? That's murkier, because it seems like the times that she was violent was with this boyfriend. And I'm not personally aware that she was violent with other people, at least in a regular basis or in any serious way. That this relationship that she had with her boyfriend was what was toxic. And there's some evidence that she has that he was violent with her at times, but it is also absolutely clear that she was violent on a fairly regular basis against him, or at least in a pattern using weapons against him, that he had been maybe even stabbed other times before by her, things thrown at him. So he'd been injured by her before. And of course, if you see the videos and the audio, you know that you can't really dispute that. There's video of her beating him. There's video of her talking about beating him. There's video of her out of control anger. So she's definitely dangerous. The question is she dangerous to anybody but the person that she did kill? And part of that, of course, is their claim for self-defense strong? If you have a very strong claim for self-defense, then you're probably not somebody who's dangerous to anybody except for whoever's attacking you. But I think personally, her claim for self-defense is complete nonsense. As we talked about earlier, she has to show that she's either worried about being killed reasonably at that time, or that she's going to suffer serious bodily harm and that she was using the deadly force to stop those things from happening. What's the evidence of that? These people had fought before, and at least as far as can be seen, the only one using weapons was her. What's the evidence she couldn't call the police or leave the place or anything else? I mean, she's tried to say that, oh yeah, he was pushing me and hitting me and things during this time. Is anybody really going to believe that she wasn't giving that back? According to her, she throws the knife from over 10 feet away and it hits him and goes 3 inches deep, cuts an artery. That's not really believable, but do you really need to be throwing knives at people that are that far away? I mean, why don't you just go into another room, lock the door, and call the police? That didn't happen. Also, after she stabbed him, apparently she called the building security first and then the police after that. I don't buy it. To me, they had a pattern of misbehavior with each other, and her side of that was to strike him, hit him, and use weapons against him. She used a weapon against him this time, and it happened to be an edged weapon that caught him in a way that killed him, right? I don't know that she intended to kill him. Maybe she did, maybe she didn't, maybe just in the rage of that moment. But she did it. She did it, and the claim for self-defense to me is extremely weak. So I think her claim that she's not much of a danger to the public only extends to the side of, is she likely to kill anyone else other than this person? And that leads us down to the last point, which is the judge balances all these things and reaches a decision, and decisions are made all the way through criminal justice system, from the decision to bring charges, how evidence is accumulated, things like this pretrial detention, things that will happen in trial, plea bargain agreements and stuff like that. The boyfriend's family has said, listen, when she wasn't arrested after this occurred, that was an example of the privilege of a wealthy white woman, that she was receiving the benefit of treatment that is not typical for other citizens. Kind of hard not to see it their way, in my opinion. Their point being that if their family member, who is a large male, had stabbed her to death, you really think he'd be out of jail because he's saying that, hey, I was scared and it was self-defense? Yeah, I don't think so either. And I don't buy her argument any more than I would have bought it from him. So you can, or at least I can, understand their point that what's the reason that she's out here? Like, why? Why is she getting this kind of treatment when it wouldn't have been likely to the benefit of my family member? And they say, hey, it's because she's white and has a lot of money. I don't know if that's true or not. I have no idea if that's why she wasn't arrested for 4 months or so. However, I don't blame the family for trying to pull that lever, or even for believing it, because it was their family member who was killed, likely murdered. And you got to do what you got to do to try and see the justice system get moving. It's not always easy to make that happen. A little more worrisome, though, is if she is let out pre-trial, that could be viewed as a racist kind of incident, when really the judge has to balance these kind of factors. The family attorney did speak again. We'll take a look at that.
What it shows, Judge, is this. If I imagine for one moment that it was Mr. Admissibility, the defendant, and God forbid, Ms. Courtney Clenney, the deceased, it is no way in heaven's name I can even imagine any circumstances where a judge would have released him. And the reason why there's been so much outrage and concern about this is because it is clear that there is a different benefit that she has received that most people don't receive. If we get this system is blind justice. Everyone should be treated equally. It was my client, he would be in custody.
So he reiterated again the point that, hey, if this were the family person, the boyfriend, and he had killed her, you wouldn't be letting him out of jail. I mean, what are you talking about? I mean, the guy's a violent nut. He would be held until trial. So hold her till trial. I just don't know if that's true or not. I don't know enough about how many cases have been like that in Florida, or what this judge wants to do or whatever. I could see the judge coming down, I guess, either way on it. So anyway, I don't blame the family for taking the position, the victim's family for taking the position that they're taking. And we'll have to see what the judge does. She said that she's not going to issue a ruling on this until sometime after Thanksgiving. I think I heard it was going to go into December. And then she'll decide whether there can be release, and if there can be, under what conditions it is. A bond, some kind of secured bond, any other conditions that she might want to put on it. Might be a bond so high that she still can't come out. I don't know. We'll just have to see what the judge does with it, and then the case will eventually go forward. Could there be a plea bargain in the case? Yeah, of course there could be. She does have a claim for self-defense. To me, it's not a particularly strong claim. But if you're her and you're looking at, hey, I've got to go to jail for second-degree murder, and you don't offer me a better deal than that, why not roll the dice? Because I may get completely off on this. The state has to look at that too. So you could have a compromise either on the charge or the recommended sentence or something like that. But it's early for that. That's what happened at the potato hearing for pretrial detention, and we'll see what happens in the case. Thanks, bye.